In communication, connectivity is everything. We ensure that the links never sleep. Quantities and qualities, all in our data service, provided.
Oh, that's fine. Thank you very much.
Welcome back, Mr. Witness.
Thank you.
Hope you had a relaxing break.
I thank God. I thank God.
Just before the break, we were discussing the incidents that followed after the April 10 and 11 tests.
April 10 and 11.
And your subsequent appointment as Minister of Justice in 2001. You informed the Commission that you presented a position paper before Cabinet. Which proposed that the students should be paid compensation for what happened. However, this was rejected by the President. And you also told us that the recommendations made to prosecute persons directly responsible for shooting at the student was rejected by the state due to national security.
Wax nga ñu tamit ne ñi nga xamne ñoo doon fetel xale yoyu pour ñu yobbu len ci kanami loi lolu tamit nguur gi daf ko bañoon ndax te ñu ne dal lu aju ci mbiri karange bi la.
We also discussed just a little bit the bill you introduced before the National Assembly, the amendment to the Indemnity Act, that is Act number 5.
Wax nañ tamit kay bi nga xamne dugaloon nga ko ci ay soppali yo xamne yang ko don def ci mbiri loi bobu ñu dugaloon nga xamne ñi yaxoon lolu loi daf leen ko teggi manam dal daf leen teg malani ki ak.
If I may read clearly so that there will be no ambiguity, is Act number 8 of 1982 amended by Act number 5 of 2001.
Wa lim yoy mu wax nak moy loi bi nombre yi nga xamne mom lañ ci joxe.
Just before we go into the questions that the follow-up questions that I will ask, I would just like to ask, as Minister of Justice, what were your duties and responsibilities at that time?
Dama la buga laaj ne jamono joju comme ka yaay won ministre biñ denkal ategi ci biir réew mi fi lan moy won sa taxawaay.
As I said, I was Minister of Justice and National Assembly Matters. They always forget about that. I was Minister of Justice and Minister of National Assembly Matters. I'd like to emphasize that.
Comme ni mala ko waxé rek dama bëgg ñuy gëna fessel di digëral nak né ma doon ministre bi sétu won wali loi ak atté ci réew mi ak lu aju ci wali négi député yi.
My role as minister was to complement the role of the Attorney General. Sorry.
Suma wala nak ne ministre mo doon ngir gëna wëral nak li nga xamné ni mo doon wali Attorney General bi.
Whose role generally is to advise. He is the head of the legal fraternity, i.e. the lawyers and the bar.
Nga xamné ni walam nak li ci gëna wëral dal moy ki yedde daf mo jité na lepp lu aju ci wali até.
And he also is the chief legal advisor to government.
Tay mo moy ki nga xamné moy jité lepp lu aju ci wali yedde ci nguur gi.
And really in other countries occupies the role of basically a civil servant. Here it's different.
te tamit ci yeneen réew nag dafay nekk nag koo xam ne nii civil servant la di liggéey ci nguur gi.
Since the Constitution of 1970.
Depuis ci loi yi réew yi Gambie na atum 1970.
The governments have appointed Minister of Justice to complement the role of an Attorney General.
Bu ko defee nag nguur yi dañ daan tànn nag ministre bi saytu wàlli loi ak atte ci réew mi ngir nag mu gën a taxaw dëgëral nag lii taxawaay Attorney General bi.
Then I think for the first time the role of Minister for National Assembly Matters was added to my roles, Minister of Justice and Attorney General.
Te kon ci boobaa nag mooy njëlbeen yoon bi nga xamee ne nii lu aju ci wàlli loi wàlli néegi député yi dal dinañ ko boole ci maqamam ministre boobu boole ko ci suma liggéey.
I stand to be corrected, but just to ensure that matters dealing with justice came through our offices, courts, matters dealing with the courts, the tribunals, and basically everything dealing with law or related to law and the administration of justice.
Suma juumee nga jàjjanti ma waaye nag jam ci lépp daal li mu ëmb rek moo nekk ne daal luñ jëmale ci wàlli loi mu ngi jaaree ci suñu office.
As Minister for National Assembly Matters, basically I linked and liaised with the Honorable Speaker and a lot of the members of Parliament. Now we were working closely and to assist them in their daily chores and requirements, just like a ministry. That ministry was tied to the Ministry of Justice.
Comme di ministre bi saytu wàlli mbiri néegi député yi tamit saay bu ne ñu ngee jokkoo dañ daan gën a jokkoo ak dama daan jokkoo kii nga xam ne moo jiite néegi député yi ak yenn ci député yi ak ñeneen ci lépp loo xam ne daal mu ngi jëm ci wàlli liggéey nga xam ne dañ ko boole suñu liggéey comme ni ministre boo xam ne ministre boo xam ne dafa taxaw.
Minister of Justice, you also occupied, you were a member, I was a member of the Committee on the Prerogative of Mercy.
Bokkoon nañ ci kuréel gi nga xam ne tamit ñoo daan dog lépp loo xam ne mu ngi aju ci wàlli njëggal yi.
Your role as Minister for the National Assembly, does it also include tabling bills before the National Assembly?
Li nga nekk ministre bi nga xam ne na yow saytu léegi député yi ndax bokkoon na ci sa liggéey tamit di feeñal ay loi ci kanam léegi député yi.
Basically, but that was the role mainly of the Ministry of Justice even before that. So it was not the role really of the Minister for National Assembly Matters, but it came in nicely.
Waaw noonu la rek ndax bu dul loolu sax loolu mooy wàlli ministre bi saytu wàlli loi ak àtte ci réew mi di àggale lu aju ci wàlli taxawal loi ci kanam néegi député yi.
So you were chief legal advisor of the Gambia government and you also tabled bills before the National Assembly.
Some bills, not all bills.
Ci yenn loi yi waaye du yëpp de.
So in 2001,
léegi ci atum 2001,
you tabled a bill before the National Assembly with respect to the issues of April 10 and 11. Can you tell us about that?
am na loo feeñal ci kanam néegi député pour ñu def ko loi mu aju nag ci mbir xew-xew boobu amoon fukki fana benn ci weeru April.
I can't remember that dealing with April 10th.
Mënuma fàtte ko daal di jëfal lu jëm ci wàlli April 10.
Was not about April 10th.
Duutoon mbiri April 10.
But it concerned the incident of April 10 and 11, this particular bill.
Okay.
Would you agree with me on that?
April 10 and 11.
I need to see the bill. It's almost 20 years.
Dama bëgg gis bill bi ndax loolu dem na ñaar fukki at fi mu nekk nii.
I have with me the Laws of the Gambia, Volume 4. You may look at it from there.
Volume 4.
Yeah, it's not just for April 10. It was a general amendment dealing with matters related to, as you can see the preamble.
Adu rek lu jëm ci wàlli April 10.
Emergencies
yëpp la.
And public incidents and so on and so. If you read it, you'll see.
Yeneen yoo xam ne
just
ni
for April 10th.
mu ngi ci aju yëpp.
But this bill was still tabled before the National Assembly almost immediately after April 10 and 11 incident.
While wala bo xamne dañ ko feñal ci kanami néegu député yi susta rek bi nga xamé né ci la xew-xew bi wessu April 10 and 11.
So it's safe to say that it was informed by the incidents of April 10 and 11.
Bon nak mën nañu wax né li sabab bi moy xew-xew yoyu amone April 10 ak 11.
You may say so, but as a lawyer, I can't say that. It was a general amendment.
Mun nga wax lolu waye ni lawyer dal mënuma wax lolu. Ndax li pour yeb la won.
Apart from April 10 and 11 incident,
gannaaw xew-xew bi amone April 10 ak 11,
was there any other unrest that occurred or public disturbance that occurred in between that period?
Ndax amone na benn fitna wala yenn tafaar yoo xam ne xewoon na ci biir réew mi ci jamono boobu?
I can't tell you, no. I'm not sure.
Munuma leerutoon ma de.
Actually, there was none.
Amutoon benn de.
Okay. So it's safe to conclude that this particular bill was informed by the incident of April 10 and 11.
Comme ko amutoon benn fitna boo xam ne xewoon na waat gannaaw boobu bon mun nañoo wax ne sabab bi April 10 ak 11 moo ko waral.
You can say that, but I can't say that.
Mun nga wax loolu waaye man de mënuma ko wax.
Well, you've told us earlier in your testimony this morning that the president rejected the recommendations of the commission to prosecute officers that were criminally liable for the incident of April 10 and 11.
Wax nga ñu fi ci gannaaw ne président bi dafa bañoon ndogal bi ngeen xam ne jëloon ngeen ko pour ñi nga xam ne ñoo nekk ci wàlli kaaraange gi ngeen yóbbu leen ci yoon atte leen ngir loolu nga xam ne defoon nañ ko April 10 and 11.
In effect, although he said they accepted the report, but in reality, they did not accept some of the recommendations.
Wa ci niñ ko defé nonu rek ndax ñom wax nañ ne dal nañu nangu nak report bobu waye nak lolu soko sélo ni mujjental dal nekku ne lo xamné ni dañ ko nangu.
To clearly answer the question, the president rejected the recommendations for the prosecution of security officers that were directly responsible for shooting the students.
He did not prosecute them.
Ndaxte wax nga ne président bi fa bañ pour ñu yóbbu ci yoon ñi nga xam ne ñoo di soldat yi doon fetel xale yi.
Yeah, for national security reasons, they said they wouldn't do it.
Waaw loolu ci lu aju ci wàlli kaaraange réew mi moo tax ñu ne duñ ko def.
And also, the president refused to compensate the victims of April 10 and 11, correct?
Ak itamit président bi dafa bañ pour ñu jox ndampaay ñi nga xam ne loru nañ ci xew-xew yooyu amoon April 10 ak 11.
Yes, as a government, as a step taken by government.
Waaw ni ay jéego yoo xam ne nguur gee ko jël.
So in essence, the government did not take action.
Bon dafa mel ni nguur gi ñoom jëluñ ci yenn jéego.
Yeah, officially they did not decide that they would compensate these people.
Wow.
He was doing his own thing, basically.
Ci ni nga xam ne noonu lañ ko nattee ci buntu liggéeykaay wi dañ bañoon ne daal duñ def dara waaye nag moom moo doon nekk di def ay mbiram rek moom.
And the amendment, the bill that you presented before the National Assembly, indemnifies government and its agent from any act or omission done in the performance of their duty when it comes to public unrest.
Soppali yooyu nga xam ne moom nga def ci wàlli luwa boobu nga xam ne dafa teg malaani kiiraay ci ñi nga xam ne yëpp ci wàlli kaaraange lañ nekk ci loon nguur gi ay mbir yoo xam ne def nañ ko daal ne bu ñu leen yóbbu ci yoon dara walu leen a tegu.
This act in particular took away the right of victims to go to the court and seek for redress for what happened to them during the April 10 and 11 incidents.
Bon dafa melni loi bi ni dafa tere ñi nga xamne ñoo ci loru seen yelleef ngir ñu mëna dem ci kanami atté kay woné seen naxar ci li nga xamne mo leen dal ñu mën ci am dëgg.
No, as I indicated, that act was passed in 1982.
Déedéet comme ni ma ko wanee rek comme ni ma ko waxee woon rek loi boobu dekk na loo xam ne ñu ngi ko séddaloon depuis atum 1983.
What we did, only amendments we made to that, I think, was in relation to the retroactivity, maybe, of the effectiveness of that act.
roxandeko biñ ci def rek
Retroactivity of that act.
mo nek na li nga xamne moy doxal na lu jëm ci walli ak bobu non.
You're coming back to accepting responsibility for this particular thing is the retroactivity of its own. It expanded it expanded it to government, the government and its agent. That's what this act did. It's on its own.
Bon dafa melni dal li nga wax moy lolu dal ne dañ ko gëna yaatal ci nga xamne modi nguur gi ak ay nitam.
And it also, this provides that you cannot prosecute the police officers that shot at the students.
Te loolu li mo wone moy ne police yi nga xamne ño fetel xalé yoyu duñ leen mëna yobbu ci yoon.
You cannot prosecute the military officers that shot at the students.
Do mëna yobbu soldat yi nga xamne ño fetel xalé yi tamit ci yoon.
Even the ones that shot and killed the students.
Ak sax ñi nga xamne ño timu bal fetel rey xalé yoyu nonu.
And the students also cannot sue the state.
Te sax talibé yi tamit mëna ñoo yobbu réew nguur gi ci kanami yoon.
For what was done to them.
Ci li nga xamne mom lañ leen def.
This act took that right away from them.
Dafa melni loi bi dafa génné yelef bobu yépp ci seen.
I don't think so. I don't agree with that.
And you by giving it a retroactive effect
li nga xamne non ngeen ko gëna doolele ngeen ko yaatal
meant that it covered April 10 and 11 incident. It was for that main purpose that it was done.
Lolu dafa melni dugalale ngeen ci biir xew-xew bi amon April 10 ak 11 ndax te sax lolu moy jubluwaay bi taxoon ngeen ekati ko.
I don't think so. An act which was passed in 1982 became effective in 1982.
Foguma ko de ndax loi bo xamne ni ñu ko passon depuis 1982 taxaw na depuis 1982.
Mr. Witness, your words not mine. You said it gave it a retroactive effect. That's what you said. I didn't say so.
Ci sa kaddu moy dafa melni yow li nga wax ne moy dañ ko gëna dolel yow lolu nga wax fi man waxuma ko.
Retroactive means that it ensures that the acts that occurred during the April 10 and 11 incident
lolu mo woné né loi biñu téralon ci xew-xewi April 10 11 bi
cannot be prosecuted.
ñooñu ñi ko defoon ñoom duñ leen yóbbu ci
meaning nothing comes out of it.
loolu moo tekki rek dara du ci faxee ko.
It stays silent.
ne dañ ko noppi waale.
It's a cover up.
loolu laxatu la.
No one can do anything about it.
kenn mënu cee def dara.
No, I don't think so.
Foguma ko.
Read the act. Let me read the act. That's not what it says. Indemnity Act had been passed in 1982, long before we came in. And that was indemnifying, once again, government officials. But when the reason why we did the cabinet paper was because government was not taking the steps for security reasons. They wouldn't prosecute, they wouldn't pay. That's why we came back to government to say, pay some compensation.
Lii nag moom depuis atum 1982 la comme ni nga ko jàngee tey tamit noonu la taxawee woon lii moo tax nag bi ñu xamee ne nguur gi nangu ñoo na def loolu duñ nangoo def dara lu jëm ci wàllu atte ak ndampaañ ñu ñëw ak kayit boobu nga xam ne ci néegi député ci néegi pencu ministre yi la ne defal yenn ndampaañ.
Well, I can read it out for you. In fact, the introduction to the bill you presented.
Let me read it.
Okay, you may.
I also mentioned that in civil liability, principles of vicarious liability ensure that an employer's employee, if carrying out the assignment of the employer, cannot be personally liable. So the police and other security officials could not bear any civil liability, at least civil liability, because they were doing their job at the time. That is a normal principle.
Kindly read.
Yeah. Date of commencement, 2nd August 1982.
Kindly start from the top, please.
Yeah.
It's
the act to indemnify government or any agent of government or any person in the service of the government or any authority acting on behalf of the government for any act, matter or omission to act or thing done or purported to have been done during the period of the public emergency and for connected matters. That was not a public emergency, only public emergencies. And that has to be declared. That's a legal terminology, the public emergency. You have to declare that. Like this, when this COVID-19 came up, I believe there was a declaration of public emergency. So April 10 was not a public emergency, as far as I know.
Mr. Witness, are you trying to use legal terminologies to explain the reason for this particular act?
No.
It is clearly seen as it is. This act was meant to cover up what happened for April 10 and 11.
No.
And there is no legal argument that can cover that.
Yeah, but look at public emergencies. It's defined. All these are technical words in an act. So when you read it as a layperson, you may assume that this is the meaning.
Should a public emergency be declared before being considered such?
Yeah.
April 10 and 11 took about, sorry, my apologies. Sorry.
It has to be declared in law for a public emergency to be effectual. You can't just get up and say, well, this act or these things which were happening, incidents, were part of a public emergency. The president must declare a public emergency. It means certain very draconian things are happening.
Comme lu aju ci wàllu jamono jotbatu kaaraange di public emergency ak comme loolu di xew-xew yoo xam ne ni dañ koy yébaane foog si rek mu nekk loo xam ne ni dañ koy déclarer pour nit ñi dal di yëg ne lii jamono jotbatu la lu aju ci wàllu kaaraange ci jamono boobu.
And the human rights of various people are circumscribed. Various things, a lot of things. You can't get out, for example, at night. There is a curfew and things like that. Normally, it shouldn't happen.
Ndax lu bari na ci yelleef nit ñi dañ ko tënk ndax mooy maanaam buñ yébaane façon yu mel noonu mënuloo génn guddi mënuloo def lii mënuloo lu bari daal di xew.
But in a public emergency, these things can happen and you cannot complain really.
Waaye nag ci jamono jabatu yi di public emergency yi mën naa am te doo am fenn foo mën a tawate lii.
Mr. Witness, I just see this thing as you shying away from responsibility. The April 10 and 11 incident took about 2 whole days.
Man li ma gisee mbir yi daal mooy dafa mel ni da nga bëgg a rocci sa bopp ci mbir mi ndaxte xew-xew bi amoon April 10 ak 11 ñaari bés la jël.
And it fills in the gap as to what a public emergency entails.
Te duggana nag ci fànn bi nga xam ne ñu ngi cee wone luwaayu jàmpa yi nga xam ne moom lañ war a tëral lan la tekki.
There was a widespread protest.
Amoon na nag ŋàñña ñaxtu boo xam ne defoon nañ ko ci.
State agents were called in.
ñi nga xam ne ñoo di ay ndawi buur yi ooyoon nañ leen.
They acted ruthlessly towards unarmed students.
ñoom na jëfi reewaange dëggal lañ defoon jëmale ko ci ay taalibe yoo xam ne amul kenn ku ci gànnaayu.
They shot and killed about 13 students.
ñu dal di leen fetel rey lu toll ci fukki taalibe ak ñetta.
Over 28 students were injured, severely injured.
lu weesu ñaar fukki taalibe ak juróom ñetta gaañu nañ ci gaañu yu métti.
That feels in exactly what this act tried to protect. This particular act indemnifies security agents and government from every form of liability.
Te loi bi nak dafa teggi ci ñi nga xamne ñoo amé karange gi wala ndaw buuri lepp lo xamne mo leen wara teggu def leen ko teggil.
That ensued from this April 10 and 11 incident.
Ci lo xamne sax mu ngi faxé ko ci xew-xew yi amone April 10 ak 11.
And you as Minister of Justice during that period tabled this before the National Assembly.
Yow jamono joju ya ne ko ministre bi seytu walu way ak até yi nga jël kayit gi feñal ko ci kanami néegi député yi.
Yeah, but it's not correct. Date of commencement 2nd August 1982. Can't you see that? I was nowhere near the Gambia in 1982. I was in England.
Why not nekkul lo xamne jaaduna ndax bes bi muy commencé moy atu ci wet ñaari fan ci wéri August 1982 te jamono jegewuma sax Gambia.
The amendment, that's what we are referring to, the amendment.
Yeah, where is it?
And the amendment is right there. Read section 1 of that amendment.
Section 1 says, this act may be cited as the Indemnity Act. Every act which is amended under the Constitution, Section 226, you must state that it's an amending act.
Can you kindly continue reading through, please?
Yeah, just a minute. Every act which is amended must state that it's an amended act under the Constitution.
Loi buñu roxande ko rek ci bi loi bi woné na dañ foxire ju woné fa né li loi buñ roxandi la.
If you don't do that,
boko defuté rek
it's not an amending act.
Nekut loi bo xamné ni dañ ko roxandi.
And this act started in 82. I didn't take it to the National Assembly.
Li mu ngi commencé 1982 té du man mako yobbu ci négi député.
And it was not a public emergency, April 10.
April 10 nekkutoon nag jamono boo xam ne nii jamono jëlbatu la.
Because it wasn't declared. It wasn't so declared.
Ndax yébaane wu ñoon.
Read through it, please.
Which one? The whole act?
The first part of it. Or
Okay.
if you may, I can read it loud for the commission.
Date of commencement. Government, etc., not liable, except as otherwise provided by the act. The government or any agent of the government or any person in the service of the government or any authority acting on behalf of the government shall not be held liable for any act, matter, or omission to act or thing done or purported to have been done. In pursuance of an act of the National Assembly or under the authority of an act of the National Assembly that authorizes the taking during any period of public emergency. You see, that's why they are talking during any period of public emergency. It's a technical term of measures that are reasonably justifiable for dealing with the situation existing in the Gambia during the period of the public emergency. In the execution of a duty imposed by a law for the defense of the Republic or the enforcement of discipline or the securing of public safety, public health, public morality, or otherwise in the public interest on or after the 30th day of July 1981. And during any unlawful assembly, public disturbance, riotous situation, or period of public emergency. The President may, for the purpose of promoting reconciliation in an appropriate case, indemnify by an order published in the Gazette such persons as he or she may determine for any act, matter, or omission to act, or thing done or purported to have been done during any unlawful assembly, public disturbance, riotous situation, or period of public emergency. You want me to continue?
Stop there. Thank you very much.
You're welcome.
It is quite clear from the wordings of that particular act that the intention behind the act was to protect officers that were directly responsible for harming students during April 10 and 11 incident. And you are arguing just based on the technical word public emergency. That argument is neither here nor there. Because the April 10 and 11 incident is and was a public emergency. And it fits perfectly into this. It is also because of that particular incident that this act was enacted. And in fact, this was the legal backing that the government used to protect its officers from prosecution.
Let me tell you that it did not protect them. Because if you don't declare a public emergency, that act doesn't apply.
Just
a minute. Secondly, they may have received wrong advice.
As
far as I can read, that act is not dealing with 2001 because no public emergency was declared in respect of it.
April 10 and 11
Was anyone prosecuted after the enactment of this particular amendment?
I can't remember. I don't know. So
You were the, sorry, my apologies. You were the Minister of Justice. And in your words, Chief Legal Advisor to the government. And also, you had the advantage of sitting in a commission of inquiry. Whose report you believed in? And according to you, certain soldiers were to be held criminally liable for what happened. You tabled this bill before the National Assembly. And even at the time when you tabled the bill, there was an uproar with respect to civil societies, human rights organizations, about the draconian nature of such an amendment. And what did you do?
I just told you, it didn't protect them. Public emergency must be declared. It's not a technical word. These are legal terminologies. If you go to the Interpretation Act,
comme ni mala ko waxe rek aarul leen ndax amutoon nag jamono boo xam ne yébaane nañ lu jëm ci wàlli public emergency.
Chapter 5 of our laws.
Suñ juróomi buntu bi ci suñ luwaay réew mi.
And under the Constitution definition section, you will see what a public emergency is. If it is not declared, it will not be a public emergency. So if the government decided not to prosecute, as far as I know, it was for national security reasons.
Kon nak bu fekkee ne nguur gi bañoon nañoo àtte ñooñu comme ni ma ko xamee rek mooy lu aju ci wàlli kaaraange réew mi.
And as far as the facts of the issues were concerned, there was actually no national security to even rely on in the first place.
Acts
such as killing and inflicting harm on citizens cannot be sheltered under national security.
As for the president, national security is the province of the president. I cannot say, as you are saying, there was no national security element. You cannot do that. All I can say is that public emergencies must be declared to become public emergencies. That act deals with public emergencies.
Public emergency public emergency.
Sometimes in the Gambia, people think they actually know what the law is from just hearing people in the street. But if you read it, you can see it says public emergency. It must be declared.
Kon nak amna ñoo xamne ni dañuy fogg rek liñ fogg rek moy léggé dara ci réew ci nit ñi ci mbedd mi ne public emergency waye fogg ci rek mu nekk nak luñ
Mr. Witness, I may be a relatively young lawyer compared to your long standing in the bar.
Mr. Sedebi xamna ne buñ ma mengalé ak yow lawyer bu ndaw lay nekk ci sa ron suñ ko mengalé ak yow ni nga yagge ci wali bunti atté bi.
But I am of the opinion
waye nak xamna ne
that this particular act with respect to the quote public emergency also covered the incident of April 10 and 11.
There is nothing like a small lawyer in my book. They are all lawyers.
Well,
but let me tell you once again that it's clear there. Public emergency, it's a hurdle you have to pass. You must jump that hurdle and have it declared as a public emergency. He didn't do that. So relying on it as a public emergency will not cut ice. It was not a public emergency. So they could have been prosecuted.
No, they couldn't have been prosecuted. Because it says during any unlawful assembly, public disturbance, riot situation, or period of emergency.
Yeah.
So it covers it, Mr. Witness. It does.
You have to show that it's an unlawful assembly. The only place where you can show that it's a public emergency is before the courts. And that court has to look at it and say, okay, the assembly of the students was unlawful. You can't just read it and say, because government said it was an unlawful assembly, so it was unlawful. No, the courthouse is where to determine that.
Ci court bi rek lañ mëna wérélé né ndaje bobu xalé yi dajé won depo ton ak yoon.
But in this regard, Mr. Witness, it does cover it. And as the chief legal advisor to the government, the custodian of justice, as at that time, you presented the bill, denied justice to a lot of students at that time, and you remained silent about it.
Oh, don't be offensive. You are very wrong, actually, to say that. I've told you that this act started on 2nd August 1982.
bu ko gisee maire de waaye nag li nga wax noonu nekkul loo xam ne ni noonu la ndax lii mu ngi dooree ci ñaari fan ci weeri August 1982.
I wasn't there.
te nekkuma woon fa.
Secondly, whatever amendment I presented,
ñaareel ba ci bëreem roxandi boo xam ne ni teewal naa ko.
did not prevent the prosecution of anybody. It's there. Either it has to be declared a public emergency, which was not done, or it has to be declared lawful not by the president but by the courthouse. Only the courthouse can do that.
Amul dara loo xam ne ni aar na leen ndax mu ngi fa ndax du loo jamono boo xam ne yéebaane nañ ne jot batu am na di public emergency te tamit nekkul na loo xam ne ni président bi moo wax rek ne seen ndaje mi dëppoowut ak yoon ñu war koo lini loi bi moo ko war a nangu ne daal seen ndaje bi dëppoowutoon ak yoon.
Thank you very much, Mr. Witness. I don't take things personally. I'm just doing my job.
No problem.
No worries about that. But with respect to this particular provision of the law, we can agree to disagree. But it covers unlawful assembly, public disturbance, riot situations, or periods of public emergency. And the law is clear on what unlawful assembly is and what public disturbance is.
Take it to the courthouse. They are the ones to determine that.
But you presented a law, an amendment, sorry, that gave a retrospective effect. A retrospective effect to a crime that was committed some months ago. And sadly, this is still in effect. It can still be used by the government to violate the rights of citizens in this country.
No, I mean, as you say, you can go on. I'm telling you that that's wrong. It has to be declared unlawful not by anyone else but the courthouse. Take it there. Take it to the courthouse. And I was not there on 2nd August 1982. This act says commencement date 2nd August 1982. It's not my responsibility at all. And on that commission, I told you what we did. We said it was wrong. In cabinet, I sponsored a paper to say, pay these people because you did something wrong to them. That's all I can do.
My apologies. Just give me a brief period to read through this. I can't see clearly. Mola, can you kindly assist in printing it, please? There is actually the judgment of the court on that particular issue that I would like to bring up.
Feel free.
But while we wait for that, We can just go on, and when it comes, I'll make reference to it.
Feel free to ask anything, please. I told you earlier. Feel free.
Well, I am doing just that.
Council, just a second.
Yes.
Commissioner is asking, making a point of order. Commissioner Bishop.
I want to ask a question, please.
Yeah, please, go on. It's a point of order.
Yeah. Now, what is confusing is the amendment that you are talking about, that he passed. When did he pass the amendment? Because he's constantly referring you to 1982.
The amendment was actually passed in April of 2001.
But it appears as if that amendment date is not there.
I cited Act number 5 of 2001. You remember he became the Minister of Justice in January 2001.
Yeah. So, but perhaps you need to point to that amendment date.
He is well aware of the dates, I believe.
What's the date?
The Act number 5 of 2001.
2001.
What Bishop is asking.
As amended by Act number 5 of 2001.
What's the date of the amendment?
2001.
No, the actual date. No.
Yes, that's April 2001. I have with me an observer, a daily observer paper that will help us situate the date. I'll just state what happened before the National Assembly as it was reported by the Daily Observer. In fact, the paper reads, "The Indemnity Bill, was it validly passed?" That's the title. And it's an editorial, actually, written by Frederick Rumpole. The report in your issue of April 19 headed Sidia Amat marched out on the proceedings of the National Assembly on the Indemnity Bill. So this tells us that the bill was passed somewhere around April. I don't know if it is April 19th exactly, but it's April, maybe before the 19th or so. But it stated that on Sidia and Ahmad Ba marched out on the proceedings of the National Assembly Indemnity Bill. Which many right-thinking Gambians, including your editorial of the same issue, considered a great act of impunity and a cover for misdeed. Raises an important point. The total membership of the assembly is 50. That was during that time. According to your report, 18 were absent. The report is actually questioning whether there was quorum. Was there quorum? 4 voted against. 5 in abstention. 2 walked out of the proceedings. And as you concluded rightly, only 21 out of 51 voted for such measures. It is thus quite clear that the bill has not received the support of the majority of the National Assembly members. Only a minority of the members voted in favor of the measures.
ñu néew rek ñoom ñoo ci àndoon.
The editorial now questioned whether the bill was validly enacted.
léegi nag ki dugal lii di laajte nag ndax luwaa bi doxal nañ ko jaarale ko niñ ko war a jaarale.
As you can see, this was quite controversial even at that time.
Comme ni nga ko gisee de lii doonoon na loo xam ne indi woon na werante bu rëy sax jamono booba.
Many of the National Assembly members believed that
am nañu ci bari yoo xam ne ay député lañ ñoom liñ gëmoon mooy ne
it was a cover-up for the misdeeds that occurred during April 10 and 11 incident.
lii daal dañ ko def rek pour nëbbatu laxatu ci xew-xew bi nga xam ne moo amoon April 10 and 11.
I don't think so, really. Again, the Indemnity Act had been passed earlier, indemnifying some officials in respect of what happened in 81, the aborted coup. Now, over there, unless it is declared unlawful in those sections by a court, nobody can conclusively say the acts of the children were unlawful. Let them test it.
Comme ni ko waxee rek indemnity boobu li nga xam ne mooy maalaanam càngaay googu noonu kaaraange googu dafa nekkoon depuis atum 1982 te itamit nag ci bunte yooyu nga xam ne noonu lañ ko loxandee day amul fenn foo xam ne ni wéral na ne xale yooyu seen daje bi dëppawutoon ak yoon foog si mu waroon a jaar ci bunte atteekaay boobu.
Need I remind you, Mr. Witness, that the Commission of Inquiry report stated that the acts of the children in staging a protest was unlawful.
ma fàttali la nag xibaar bi nga xam ne moom lañ ca feeñal mooy ne xale yi pour ñu dajale seen boppa di wane seen ñaxtu yooyu àndul ak luwa.
And you were part of that commission.
Even there, even if we said that, is the courthouse. A commission of inquiry cannot conclusively hold that kind of thing. It's the courthouse which can decide that.
Donte fofu sax ci commission of inquiry sax nga xam ne nii bokkoon naa fa même su fekkee wax nañ ko fa sax court bu mag court rek moo mën a dëggal loolu.
Yeah, but it's not the 1982 Act that is in question at the moment. What Bishop was asking about, which is a very valid question, is the amendment. And we're trying to find out what the date of that amendment was. And you were around as Attorney General, Minister of Justice, and I believe you have 3 hats on at that time. There's a Minister for National Assembly Affairs. What is being inquired at the moment is the date for the amendment.
Yeah, I can't tell the exact date.
Well, somebody must be able to tell us. You can't have laws of the Gambia out there, and you don't. Nobody knows here when that amendment was passed.
Passed, yeah, because it says number 5 of 2001.
I'm not worried about that. All I want to know is when was that amendment passed.
Yeah, I can't say the exact date. No.
Mr. Chair, if I may come in, it's not an issue of when, because the when has already been established. It was during his time as Attorney General.
The date we want to know, because he's the one just questioning.
The amendment, as it is stated in the law, it's cited like this: Act number 8 of 1982, amended by number 5 of 2001. But the month is not stated. It's the year in question, and the year in question, he was the Attorney General, which he admitted that he was the Attorney General, and he has also admitted that he was the one that tabled it before this particular amendment, before the National Assembly, if I'm correct to say so.
You have to guide me on that. I can't say anything now off the cuff. 2001, I became minister end of January. I think I started my functions either 1st February or whatever, but I was appointed around the end of January.
If I may, speaking from the bar, like speaking with authority here, I did make an inquiry with the Ministry of Justice as to whether he was the one that tabled the amendment before the National Assembly, and they confirmed that yes, he was minister at that time and he tabled it before the National Assembly.
am na gëstu bu ma def nag ci suma wàlli liggéey pour laajte ndax jamono ji nga xam ne ñu ngeen wone soppali yiñ def ci wàlli luwaa yooyu moom moo fa nekkoon ministre bi saytu wàlli atte gi te wëraloon nañ ma ne waaw moo fa nekkoon.
Yeah, man, I think council has also read an article. And what's the date of the article?
And the article I read is dated, sorry, my apologies.
April 19th?
April 19th. That was when they stated that Sidia walked out of the proceedings of the National Assembly. And he was appointed sometime in January as Attorney General and Minister for National Assembly. So it is within his time or his tenure as Minister of Justice.
Wali ñu ko binda wéri April ci at moomu noonu te moom wéri January lañ ko defoon ministre bon dafa mel ni jamono boobu mu ko fa fekkoon.
I stand to be corrected, Mr. Witness. If that's not the case.
As I said, I'm not ready to be volunteering dates which are 20 years ago, but you can do that.
Waar naa la man nekkuma ku fee mën a nekk rek di seet bés déet yeeg yooyu noonu bés bi mu nekk ndax loolu about lu dem ci ñaar fukki at ci gannaaw la.
Mr. Chairman, if we can just skip this point, I can undertake to provide the bill that was actually presented before the National Assembly bearing his name. That will be tendered as exhibit to show that indeed he was the one that tabled it before the National Assembly. But not today, Mr. Chairman.
I would want to have a consultation conference with the two of you at some point. So maybe you can skip this point now and then find out exactly what is happening and inform the Commission. We can't go on like this and that we don't even know the datum of effectiveness of the amendment.
I'm grateful, Mr.
He mentioned retroactivity. That's very important. That's why I'm insisting on wanting to know when the amendment became effective.
Yes.
I'm certain that it was April, Mr. Chairman.
Well, anyway, let's have a consultation thing and then try to sort it out. We can't do it like this at the moment. But continue, Council.
Mr. Witness, just to take a cue from Chairman, we'll move to other issues while we'll try to verify these other issues that have popped up.
Léegi nag ñu continuer ci leneen balaa ñu jeexal lii.
I will come back to the amendment on the Indemnity Act.
Dinaa dellu si waat nag ci mbiri soppali nga xam ne moom lañ def luwaa boobu.
Just so as we will not waste time.
Pour rek ñu bañ a tardé.
You've also initiated several amendments on the Constitution.
Yow nag am na ay xalaat yu bari yoo xam ne def nga ko ci soppali yu ñu def ci luwaa réew mi.
And one of such is the inclusion of secular in Section 1 of the Constitution.
Ben bi bokk na ci dugal mbiri secular moo di réew mi du dox ci benn diina dugal nga ko woon ci mbiri.
What can you tell us about that?
That is correct. We initiated that.
Waaw dëgg la commencé woon nañ loolu ñoo xalaatoon loolu.
I think the idea was there was a clear indication of people coming in with extremist views and intolerance was growing in the Gambia. And we felt that it was important or opportune to nip it in the bud because the Gambia has always enjoyed peaceful coexistence among its various groups of people.
Am na yenn jamono wu daal ni ñange xabaabal di jéggi dayo ci mbir yu mel noonu te tamit daal ñàkk masla mu ngi doon am ñu gis ne jaroon na itamit nag pour ñu dugal ci lu mel nii ndax jamono Gambia nekk na réew moo xam ne ni ci diir bu yàgg ñu ngi bànneexu ci jàmm ak dëkkin bu neex.
And we saw what was happening in other countries where extremism had taken hold.
te tamit gis nañ nag li nga xam ne nii moo daan am ci yeneen réew yi te tamit nag ñu gis ne daal yu xabaabal yi naka la daan amee foofu.
So we felt it was a good time to bring in that kind of amendment to help all Gambians, not just majority or minority, everybody in the Gambia.
bu ko defee nag ci lañ wax ne daal war nañoo indi nag loolu ñu daal di def soppali mbir moomu ndax pour dimbale nekkul rek benn boor ci Gambia waaye ñëpp ñi nga xam ne ñoo nekkee fii ci réewi Gambia.
The proposed inclusion of the word secular into the Constitution.
Liñ xalaatoon na pour jóge ci baat bi ñoo wax secular ci biir loi réew mi.
It was challenged by Kemeseng Jame before the Supreme Court.
Kemeseng Jame na dingatoon na ko ci kanami Supreme Court bi.
Stating that that particular provision of the law was entrenched.
De wane ne li nga xam ne fànn boobu ci loi bi la génnee nañ ko fa.
And the inclusion of the word secular was null and void.
Li tax ñu dugal ci kàddu googu secular loolu amutoon njëriñ.
And of no effect.
Te amutoon benn taxawaay bu mu war a jël.
By reason of its uncompliance with the provision of Section 2264, which provides for the manner in which to deal with entrenched clauses that are in the Constitution.
Ndaxte àndul ak li nga xam ne mooy fànn bi ñu def ci wàlli loi bi ci ay soppali yoo xam ne dañ koo def ci loi réew mi.
Can I get your reaction on that, please?
What do you want me to say? Yeah, there was an amendment.
Wow,
But ask whatever you want.
As at the time when you were making the amendment, you knew that that particular provision of the law was entrenched.
It was not entrenched, as far as I'm concerned.
But the ruling of the Supreme Court, in the case of Kemeseng Jame and the state,
why Supreme Court clearly
state that that particular provision of the law was entrenched and it should not have been tampered with.
Yeah, that came later. That came later. But when we took this particular amendment to the National Assembly, we looked at the provision. And if you look at the 226(4) at the time, it's saying subsection 4 applies to sections 1 and 79(2), which relate to the sovereignty of the Gambia. That's very important, because in the interpretation of statutes, what is in brackets will not occupy second place. It's as effectual as all the words which are outside. And our reading was that it was only dealing with what related to sovereignty. Section 1 talks about sovereignty and secular republic. So we amended the republican nature of the Gambia, not the sovereignty of the Gambia, which Section 1 was entrenching.
Mooy nag li nga xam ne mu ngi jëm ci xat boobu nga xam ne dañ ko ñàkk ne kenn mënul koo wëlbati ñu seet si na ñaari xaaj benn xaaj bi nag li nga xam ne mu ngi jëm ci wàlli réew mi ne moo nekk na réewam boppam ak li nga xam ne mooy mbir lu jëm ci wàlli secular boobu ñu ko ñàkkoon.
Just a minute. Otherwise, why would the Section 1, if it's so clear and it's saying sovereignty, why should the draftsman go on and say which relates to the sovereignty of the Gambia? It's already known that sovereignty is in Section 1. Why should they go on and try to explain to people that that section relates to sovereignty of the Gambia? There would be no need. Otherwise, the republican aspect should have been in a different subsection, but it's in the same section, so that those words relates to sovereignty of the Gambia. Republican status does not necessarily relate to sovereignty. It's a different thing from sovereignty. So you can amend what is not referred to in the brackets, which is anything other than sovereignty. And so we did that.
Mu ngi mel ni comme booy roxandi rek wala ci wàlli coppali yoo xam ne dana am nekk ne li nga xam ne dañ ko ñàkk loolu moom mooy li ci des te moom mu ne def nañ ko ñoom.
Mr. Witness, regardless of your interpretation of that particular provision of the law, the Supreme Court, which is vested with the authority to interpret and determine the validity of a particular provision of the law, made a ruling with respect to the amendment you introduced and said it was null and void. It is the Supreme Court that has the power to do so.
The Supreme Court
and not the Minister of Justice. Would you agree with that?
Yeah, subsequent to the amendment, that was what the Supreme Court made that ruling after the amendment had been made. And if you go again to section 226.4, you cannot remove anything from an entrenched clause. Since they said it was entrenched, you cannot remove the word from that section until we go to a referendum. That's what is happening.
amul ben wécceeku bo ci mëna def ndere rek ñu dem ci woté digënté waaw ak dit di referendum.
Sorry, forgive me just to read that. Let me just see. It's subsection 4 says a bill for an act of the National Assembly altering any of the provisions referred to in subsection 7 shall not be passed by the National Assembly or presented to the President for assent unless then it goes on to talk about the 3/4 requirement and the 50% requirement. So since the court said that this particular section is entrenched, it goes straight to subsection 4, which says any word in the entrenched sections cannot be removed by anybody until you go to a referendum. So to remove that word, we have to go to a referendum.
But the word was put there unlawfully because it was not part of the 1997 Constitution. It was put there after the 1997 Constitution was passed.
Why bat bobu dañ ko ci duggal gannaaw bo xamé né loi 1997 bi joxal nañ ko ba paré.
Yeah, but that subsection still applies to anything amended. Anything which comes in 1997 or after 1997, if the court holds that it is entrenched, you must go to a referendum to change it. So to remove this particular word, we have to go to a referendum because of subsection 4 of section 226.
Madam Interpreter? Oh, you didn't catch all of it? My apologies. Mr. Witness. The 1997 Constitution did not have the word secular in it. You, as Minister of Justice, imputed the word secular in an entrenched provision of the Constitution.
Ya dugal baati secular ci loi bo xamne dañ ko ñak manam dañ ko ar ba nga xamne waruñ ci soppi dara waruñ ci yokka waruñ ci wañi.
The Supreme Court ruled that the word that you have imputed into the 1997 Constitution was unlawfully added there. And therefore that particular word, the addition of that particular word is null and void. The Constitution that people voted for in 1997, even though we've received extensive evidence that certain provisions were removed. But then that is the Constitution that was voted for by the people. So you in turn decided to add another word that was not even there before. And the Supreme Court, which is the Supreme Court of the land, vested with power to determine the validity of a particular law and the interpretation of the law. It provided that that word, putting that word there, was unlawful and it was null and void. Is that not the case here?
What I'm saying, Madam, the court has made a decision, but you then have to go back to the Constitution, which says if you remove a comma from this Constitution, in a section which is said to be entrenched, and the court has held that section 1 is entrenched, and the word is in an entrenched provision, you have to look at subsection 4, and it tells you any bill shall be passed. You have to pass a bill to remove that as well.
Comme ni ko waxee woon rek bu fekkee ne court bi dal dina def dogal bu mel noonu tey foog si rek ñu wuññeekuwaat ci luwaay réew mi ndax bu fekkee nag ne luwaa la boo xam ne ni dañ ko ñàkk te wecceeku foog si rek mu war a jaaraat ci génne benn loi teg si beneen loi.
Secondly, I did not pass that amendment.
ñaareel ba du man maa àggale nag amendment loi boobu.
I would like to enlighten some of our people again. The procedure for passing an act is the MPs are the people who pass it, and the president will sign and assent to it, then it becomes an act. Not Joof or the Ministry of Justice. They cannot pass any act or any amendment.
Tey ma leeral fii pour wéral nag loi boobu noonu bu néegi député yi ñoom ñoo ko war a sànni nangu ko président bi dal di ko yéwénal waaye nag du Joof wala ministre bi saytu wàlli loi ak àtte moom moo koy def.
You, Mr. Witness, presented it before the National Assembly.
Yow mii na yaa ko feeñal ci kanam néegi député yi.
You don't pass it. The two are different.
You tabled it before the National Assembly.
Yow yaa ko génne teg ko ci kanami National Assembly néegi député yi.
An act is not passed by the minister presenting. It's passed by two sets of people. MPs plus president. You have an act.
Loi nag li koy dëgëral mooy li koy taxawal mooy ñaari bunta néegi député yi ak président bi nga am bunta.
No minister can pass an act.
amul benn ministre bu ko mën a taxawal.
Mr. Witness, did you or did you not table this particular amendment to the 1997 Constitution before the National Assembly?
I said I did it, but I didn't pass it. These are terminologies.
wax naa la ne maa ko yóbbu ci néegi député yi waaye nag du na man maa taxawal loi boobu.
So you tabled it. You're admitting that you tabled it before the National Assembly.
But I told you I
léegi
did.
nangu nga ne yaa ko feeñal ci kanam néegi député yi.
waaye wax naa la def naa loolu.
I tabled it. I presented it. But I cannot pass an act or an amending act. Only the MPs and the president signing, assenting can do that.
As Chief Legal Advisor to the government,
yow nga xam ne yaa jiit ñi nga xam ne ñoo joxe ndigal pour nguur gi.
you are supposed to advise the government on legal issues, correct?
li nga ko war a digal rek mooy loo xam ne mu ngi aju ci wàlli loi.
And it is through your advice that the government carries out certain things.
yow ci sa ndigal yooyu ci la nguur gi di sukkandiku pour doxal yenn ci ay jëfam.
And in fact, you are the chief draftsperson for the government because every bill passes through your office and you table it before the National Assembly.
te yow sax yow yaay njiit li ndaxte loi boo xam ne tëral nañ ko sa office daa jaar nga ñëw feeñal ko ci kanam.
Let me guide you there. When bills come in, they sometimes come in from different ministries. Fisheries can sponsor, agriculture, everybody can sponsor a bill. Now they can go through the drafting section.
Karama tete la fofu loi bu ñëwé mën na joggé ko ci bunta yu bari ci ministre bi saytu li ministre bi saytu lele buñ paré nak ñu jaarale ko na ci ñi nga xamné ñokoy bind.
When it is not presented by the Minister of Justice,
bu fekkee nag ne àggale ko la di ministre bi saytu wàlli loi ci réew mi.
When they finish, they take it back to the particular ministry, local government, fisheries, agriculture, and they present it before Parliament.
bu koy fee nag boobaa buñ bindee loi bi ba pare dañ koy delloowaat ci ministre bi nga xam ne nii moom ca lañ ko jëlee woon mooy ministre bi saytu wàlli napp gi wala yeneen.
Mr. Witness, just a quick question before you proceed.
That did not come to me as minister. Only bills which were to be tabled, sent to Parliament or presented by the Minister of Justice and National Assembly matters or the Office of the President.
Mr. Witness, where is the drafts, legislative drafting office? Where is it?
There's an office in the Ministry of Justice.
And it's under your ministry, correct?
Yeah, it is.
Wow.
But not every bill will come to me as minister. That's what I'm saying.
But as Minister of Justice, you assume responsibility for every bill that is passed under your office.
No, I cannot. Those who present their bills, they take responsibility. My staff will help them in drafting.
Suma liggéeykat yi nag ñoom ñoo leen ay dimbale pour bind loi bi.
But that's where it is.
Mr. Witness, in this case, are you running away from responsibilities, if I may ask?
I never do that. I never do that.
Because this particular amendment, Mr. Sow did testify before the commission that you tabled this particular amendment before the National Assembly, amending an entrenched provision of the Constitution.
I took it there. I don't know why you keep asking that. I said I took it to National Assembly. And it was, as far as we were concerned at the time, that provision was not wholly entrenched. Only the portion relating to sovereignty was entrenched. As you can see the words in the brackets, it says relates to the sovereignty of the Gambia. Not the Republican status, which is what we amended.
And given that proper procedure was not followed in carrying out this particular amendment, it created more room for the executive to tamper with the Constitution, because this was the first of its kind.
No,
amendments were made. Since 1997, many amendments were made to the Constitution. That was not the first time it was amended.
1997. No. Amending an entrenched provision of the Constitution, this was the first.
I am saying it was not entrenched. That was our view. That portion of Section 1. Because if you look at it, it's also talking about Section 79.2. If you go to that section, it's also talking clearly about sovereignty of the Gambia cannot be compromised. They did not want the Gambia to be a subservient state to any other country. So they were more interested in sovereignty, not whether it was a republic or something else.
Mr. Chairman, I'll leave the Commission to decide on this particular issue, looking at the case of Kemeseng Jammeh versus the state, to come to a conclusion as to this particular issue. After this particular amendment, several amendments were also introduced by you, Mr. Witness.
Very well.
An amendment was made. That's Act number 6 of 2001.
Act number 6, 2001.
Giving powers to the president to appoint chiefs.
Yes.
Wow.
Carlos.
From the key.
Yes.
Yeah, I remember that.
Wow,
can you tell us what informed this particular amendment to the Constitution?
Now, the preamble of the amending act would probably say that. But as far as I'm concerned, I think the idea was to ensure that every Gambian is able and entitled to be a chief. Once you are a Gambian and you meet the basic requirements, you should be in a position to be a chief. You don't have to be born into a particular family to be a chief or alcalo. We didn't share that view. I don't share it. I still don't share it.
Fofu nak liñ fa bëgg na léral rek yaakaar naa jubluwaay bi moo nekkoon ne képp koo xam ne doomi réew mi nga yow yelloo nga nekk chef ci réew mi boo xamee ne daal am nga màcc nga nag ci li tax ñu lay tànn mën nañ lay tànn waaye na du ne rek da nga war a jógee ko ci genn façon yi njaboot rek benn geñoo rek pour nga nekk chef loolu moom man àndu woon ci te ba tey.
Prior to this amendment,
lu jiitu
there was already a traditional system in place that was working well for the people.
Why are you saying working well, madam?
If you may, let me just proceed with my line of questioning. Thank you. A case was instituted against the government. That is in the case of Jabi versus Keba Fanta Koma and others. This case was as a result of the president appointing an alcalde. No, sorry, a chief. And the individual, that is Jabi, who had the authority to stand as chief, was denied his right, and he took the matter to the Supreme Court. And when the matter was before the Supreme Court, they ruled in his favor. And it is as a result of this particular case, which was in 2000, that the state introduced this amendment. And it is argued that the amendment was done so as to give Jammeh the control over traditional leaders. And not necessary to provide qualified Gambians the right to become chiefs or alcalos. It was a strategy to entrench himself in power.
I don't think so. I don't think so. You see, these are all political matters. You can always fit in something in there.
Like
you're playing football, as you walk along the sand, you kill an ant. It happens on the way.
Mr. Witness,
well, what was the purpose was that in the past, especially in some parts of the country, a particular family was inheriting this chieftaincy and alcalorship, and some of them were not doing it properly.
Gis nañ ni réew mi fi amna yenn genn façon geño go xamné ni ñom ñoo daan donnante rek geño buur yaagi.
Nepotism, corruption, and all kinds of things were coming into it, and that was to stop it.
And you decided to give the total authority and power to one single individual who also used the same tools and even in an enhanced form. Tribalism, nepotism, in his selection of alcalos and chiefs in order to entrench himself further in power.
No, anyway, as far as I'm concerned, the reason was to give Gambians more opportunities. You can't be in your country and then you cannot occupy certain offices.
Pour nak ñu mëna am falute yoy ndax nek rek ci réew mi té mënulo fexé ba falu ci dara.
Mr. Witness, if that was indeed the reason for it, don't you think that there could have been other safeguards in the local settings to ensure that alcalos and chiefs are properly appointed, and not to give a single individual the power and say, take, do as you will, appoint anyone you want as alcalo or chief?
If you've been throughout the Gambia, as I have been, and you know the local areas and how our societies are organized, you know that there is no other way to remove a chief or an alcalo and put in somebody who's been to school or somebody who's more qualified. The people are under his constant authority, the chiefs and alcalos.
Commissioner Kinte wants to raise a point of order. Can you please go ahead?
Mr. Joof, I think Mariama is just too young. That's why he couldn't defend her case. The chieftaincy was based on a semi-autonomous democracy or whatever. It was the compound heads, village compound heads, that vote for the chieftaincy. All right? What the president has those days was to endorse the appointment. But there was some element of democracy that was happening. And that was instituted in order to discourage this lineage transfer of authority. So instead, Yaya dismantled that and reinstituted the dictatorship approach, that the president has to decide who. It can be the same family continuously, and it can be any rank and file. In those days, it was the elders of the community that come together to screen individuals for their suitability and vote. There is some amount of campaign, some amount of democracy exercise, and so on. So it wasn't as you tend to present. It was in the same family all along. I can give you examples all around the Gambia that we are changing from house to house, like Kintekunda to Saba and so on. Salikenya to Njaba, and I can name it. That wasn't it. It may even stay in the same village, but from different clans.
What's the point of order?
What's
your point of order?
My point of order is, what he is saying, that the amendment came to improve the past was in fact not right. The amendment came to disorganize the past.
Thank you.
It wasn't a merit, it was a demerit.
If you have any response on that one before I give the council. Council, you may continue.
Yes, Mr. Chairman, thank you very much, Commissioner Kinte, for that. However, we are not talking about the traditional system here. We're basically talking about an amendment that was made giving sovereign power to an individual, ignoring the traditional setups that have already been in place. I am well aware that the selection of chiefs and alcalo varies from one village or the other, depending on their traditional practices. And it was working perfectly for them. These traditional structures were working very well. However, there was this particular amendment to the Constitution which varied the traditional system and gave absolute power to the president to select who he wants as chief or alcalo of a particular community without consulting the community.
mu dolel nak president bi ba nga xamne mom moy tok rek set ko ko doy rek mu jël ko tan ko def ko chef wala alkali te sax du jokko ak ñi nga xamne ñoo
so it was left to the whims of the president to do as he pleased.
dafa desoon rek ci president bi mom lu ko neex rek mu dogalé ko non.
That is my question to the witness here.
Wa lolu nak mom lay laaj sédé bi fi.
So that particular amendment seek to give total power and control over the traditional structures to the president.
Soppali bobu ngeen def dafa jox doole gu mu sekk bo xamne daf ko jox président bi pour mu duggal loxom ci li nga xamne non lañu aada woowon daan jëlé chef yi ak alkali.
No, madam, I don't agree with you. It wasn't working well at all. Anybody who knows the provinces, and I know the provinces, been all over the place, all over the country. You see that the chiefs used to come from a kabilo. It's not from the same compound, but it must be from the kabilo. The kabilo may be in Badibu Saba or Kintekunda or Fatoto, but it's the same family.
Why not Foxy Genyo go gene bari Kintekunda wala Saba wala Besa Fatoto? Why again the Genyo Geregla?
Well, you need in a democratic society to spread it out. Everybody, no matter who they are, they must be able to vote. Once they satisfy the residential requirement in the area, they have a right to be chiefs and alcalos. I still think so.
But rek lima japp rek mo nek ne rek kep ko xamne nek na ci rew mi rek fox nga ndigam am nga yelle fi wote war nga falu.
And somebody must appoint you. Somebody has to appoint the chief.
Tamen fek ci kenn ab tan la.
Did the chiefs and alcalos protest as to the manner in which things were done? Did they send a position paper complaining as to the manner in which things were done during that time?
Sefi ak alkali na am na yen kayit yo xamne woné nañ ko di tawat anam yi nga xamne non la mbiri daan doxé jamano bobu.
What do you mean? Protest to who?
Did they send a request or a protest paper stating that the traditional means in which they selected their chiefs or their alcalos was not working for them?
Ndax yónnee nañ kayit boo xam ne ñu ngi cee wone seen ñaxtu bu wone ne anam yi ñu tànnee alkaale wala chef yi neexut leen.
I don't know. All I know is that we were given the mandate to present this amendment to the National Assembly, and we did.
Xaw ma daal ndax ñun daal li ñu sasoon rek mooy ñu dal di dem yóbbu lii pour ñu roxandi ko wala soppali ko ci néegi député yi te def nañ ko.
And I still think it was right.
Ba tey yaakaar naa ne loolu jaadu na.
Did the president give an opportunity to the communities to vote as to who will be their chiefs before he selects the individual and have him to be chief over them?
Ndax président bi joxoon na doole ñi nga xam ne ñoo dëkkee ci tunda yooyu pour nag ñu tànn ki nga xam ne moo leen doy pour mu nekk seen chef wala seen alkaali.
It was not the tradition, so I don't know whether he did that. Chieftaincy in Gambia was hereditary. It should not be hereditary. It should not be hereditary.
Can't get into the debate on that one. No, just a second.
Since that is not the case either, that means that you gave powers to an individual to dictate as to what communities, the leader that the community should select. Sorry, if I may rephrase that, to dictate a particular or to impose a leader on the communities. And that on its own encourages dictatorship, Mr. Witness.
I don't agree with you, Madam, definitely.
Well, it does. I'll give you an example. Mr. Chairman, if you may recall, Mr. Kemeseng Jame testified before the commission. An incident that happened in his village. The community leaders met and selected an alcalo. The president imposed another alcalo on them. And their rates were rejected because they paid to the alcalo selected by the community. And to make matters worse, the chief sentenced them to 6 months for not paying their rates to the alcalo that was selected by the president, that was imposed on them. Rather, by the president.
I don't know the details of these cases and the background, but truly speaking, every Gambian is born free and equal. They have a right to be chief, president, or alcalos, as far as I'm concerned.
xam nak mbir mi nak fu mu jóge ko ak nu mu mujjee de waaye nag li ma mën a gaaral mooy doomi Gambien bu ne am na yelleef pour ñu tànn la nga nekk njiit.
Mr. Witness, the amendment that you tabled before the National Assembly, giving absolute power to the president to select chiefs and alcalos for our communities, created several problems, political problems, in this nation.
seede bi kayit bi nga xam ne moom ngeen feeñal ni pour dooleel président bi muy tànn ay njiit ci tunda yooyu noonu indi na jafe-jafe bu rëy boo xam ne def na ko ci suñu gox.
And it also enabled Jammeh to further entrench himself in power by putting his allies as chiefs and alcalos, imposing them on the people.
te loolu sax dafa gën a dooleel Jammeh mu gën a mën a toog pour dëgëral palaasam jamono joo xam ne loolu dina war a tax ba moom mooy tànnal boppam ñi ko doy def ko ci dëkk yi pour ñu jiite leen.
You want me to say something to that?
You may if you wish.
Yeah, I'd just like to say that chiefs and alcalos, they did not need the appointment by the president to show their loyalty, because the tradition is that any government which comes in, the chiefs and alcalos, they show absolute loyalty. That has been the tradition in the Gambia. Only a few may be stubborn, but mostly, you know, even if they were not appointed by the president, they believe that since he was the president, they should show their loyalty and accept whatever the president, you know, told them to do. It's the nature of the Gambian culture and society.
Sefi nak ak alkali nekku nak ne dañ wara wone nak seen koluti ci président bi rek moy tax ñu tànn leen déedéet lii nag aada la fi ne soo fi nekkee chef wala alkali ndege moom mooy président bi toog rek foog si nga toppoo ci moom.
So Chairman, it's already past our break time. I think this is a convenient place to stop.
Fine, we'll do that. Just one point to make clear to the witness. We are here to establish a record of what happened. And the context in which you're being questioned now has got something to do with the decrees, the amendments that were passed during the Jammeh era while you were Attorney General. You to help us know the genesis of those amendments and then the context in which they were adopted. And so if we come back, if we can just continue, you assisting us, giving us information on the genesis of these amendments and how they really developed in the administration. That's what we are looking for.
It's my pleasure.
Not back and forth, not getting us anywhere. But I do need to see the witness and counsel on the consultation that I referred to earlier. We will come back at 3 o'clock. Meeting is adjourned. Thank you all very much.
Thank you.
Sorry, Kinte, I couldn't come back. Yeah, I didn't want them.
Assalamualaikum. Defuñ nak lu dul rek demal lañ ba Austria jëndal lañ jesna fam gëna piré jesna bi gëna ndaanaale ci jesna yi ñu naan ko Magnum XL ak Magnum Air. In fact Magnum Air sax dafa gënangut waaye di ngeen ko dégg ci kanam tuuti rek moom laa leen indil waa Gambie xam ngeen ne yebuma leen xeebuma leen te duma leen foto man yéen lay bëggee xangañ loolu lañ nam ma nag ma indil lañ mu ngi nii loolu lañ nam ma ci jes na rek xolo boo lañ nam ma ak design boo lañ nam ma rek egsi na manaan lañ nag egsi lañ mu ngi nii skincare plus laati de xam ngeen ne rek suñ plus yi comes in so many different ways. Our musical ma tuuti xangañ waaw seen boo jëla maa gànje axankay waaw waaw Skincare Plus of the Gambia niñ leen ko taamoo di defalee rek mun ngeen ñoo jot ci number yi bu dee Gambia fii la call lañu si 36 99 137 bu dee yaa nga United States nag call ñu si 347 731 0071 te naan lañ nag suñ contract bi DHL mu nga fam ne woon ba léegi foo nekk ci àddina rek boo ñu ne ring ñu jaay la paagal la ba pare yónnee la ko ci ak nu gën a yombee xam nga rek fañ ne woon fala ba léegi number si naka la 347 731 0071 mooy United States suñ number bi fii locally fii ci Gambia fii mooy 36 99 137 te naan la ngeen number yëpp a ngi WhatsApp boo ñuy call dañu am noonu rek la nag waaw.
Danoo gëj a gisee lool namoon naa leen danoo gëj a gisee lool mbaam du ca dee doomi mbaam du ca dee ndawa kamu miin saa yi ko gisul jooy.
asalaamaaleykum 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 defuñ nag lu dul rek demal lañ ba Austria jëndal lañ jes na fam gën a piree jes na bi gën a ndaanaale ci jes na yi ñu naan ko Magnum XL ak Magnum Air in fact Magnum Air sax dafa génn ngut waaye da ngeen ko dégg ca kanam tuuti rek moom laa leen indil waa Gambie xam ngeen ne yebuma leen xeebuma leen te duma leen footoo man yéen laay bégee axankañ loo lañ nama nag ma indil lañ mu ngi nii loo lañ nama ci jes na rek xolo boo lañ nama ak design boo lañ nama rek egsi na manaan lañ nag egsi lañ mu ngi nii Skincare Plus laati de xam ngeen ne rek suñ plus yi comes in so many different ways. Our musical matuti, ahankay. Wow. Man sen bo jela ma ganje. Ahankay. Wow wow. Skincare Plus of the Gambia niñ leen ko taamoo di defalee rek mun ngeen ñoo jot ci number yi bu dee Gambia fii la call lañu si 36 99 137 bu dee yaa nga United States nag call ñu si 347 731 0071 te naan lañ nag suñ contract bi DHL mu nga fam ne woon ba léegi foo nekk ci àddina rek boo ñu ne ring ñu jaay la paagal la ba pare yónnee la ko ci ak nu gën a yombee xam nga rek fañ ne woon fala ba léegi number si naka la 347 731 0071 mooy United States suñ number bi fii locally fii ci Gambia fii mooy 36 99 137 te naan la ngeen number yëpp a ngi WhatsApp boo ñuy call dañu am noonu rek la nag waaw.